Good morning, friends. The question in this presentation is: can subsequent addition of more serious offences to the FIR be cause of cancellation of bail? Now, I am discussing, before answering this question, I am discussing the main allegation which were later cropped in the FIR. The bench was considering an appeal filed by a model who alleged that the accused businessman raped her after luring her with offers of modeling assignments. The FIR did not initially mention the offence of rape and was registered for the offences punishable under sections 354, 354B, 506 of IPC. The magistrate granted bail to the accused. Later, the victim filed a complaint before higher police authorities stating that the investigation was not proceeding on the right track. Following that, her supplementary statement was recorded and offence of rape, that is section 376 IPC, was included in the FIR. The police also moved for cancellation of bail on the basis of supplementary statement. The magistrate allowed the application to cancel the bail. The accused, meanwhile, moved the Sessions Court for anticipatory bail with no success. Later, the accused got anticipatory bail from the Bombay High Court, against which the victim moved this Supreme Court. The Supreme Court noted that High Court was swayed by the star variation in the narration of the prosecutorist. In this regard, the Supreme Court noted that though the offence of rape was specially mentioned in the FIR only at a later stage, even the first statement of the victim had the ingredients which are necessary to constitute the offence of rape. Based on precedent Prashanta Kumar Sarkar versus Ashish Chatterjee and another of 2010 SAC 9496, which discussed the consequences of adding grave offences to the FIR. The judgment authored by Justice Kohli observed that addition of serious offence can be a circumstance where a court can direct that accused be arrested and committed to custody, even though an order of bail was earlier granted in his favor in respect of the offences with which he was charged when his application for bail was considered and favorable order was passed. The recourse available to an accused in a situation where after grant of bail further cognizable and non-cognizable offences are added to the FIR is for him to surrender and apply for afresh for bail in respect of newly added offences. The investigating agency is also entitled to move the court for seeking the custody of the accused by invoking the provisions of 437 subclause 5 3 and 439 subclause 2 further subclause 34 of the Criminal Procedure Code, falling under Chapter 32 of the statute that deals with provisions relating to bail and bonds. The court also noted that the gravity and seriousness of the allegations and financial stature and position of the accused against the victim were not considered by the High Court. The court also criticized the High Court for not allowing the intervention of the victim in the bail application. No doubt the state was present and was represented in the said proceeding, but the right of the prosecutors could not have been whistled down for this reason alone. In a crime of this nature, where ordinarily there is no other witness except for the prosecutress herself, it was all the more incumbent for the High Court to have lent its ear to the appellant. In this context, the court referred to the judgment in Jagjit Singh and others versus Ashish Mishra, Las Monu and others of 2022. which held that a victim of the crime has the right to be heard in a bail application of the accused. So, so the Supreme Court in the end reiterated that subsequent addition of more serious offense to an FIR is an circumstance for the court to cancel the bail granted to it. Thank you for watching. God bless. See you again.